Hi. In this video, we're going to review some of the rules that we've learned concerning bases for enforcing contracts. Let's start by talking about the requirement of a basis for enforcement. We saw 4 general principles. First, and perhaps most importantly, when the plaintiff sues the defendant for breach of contract, the plaintiff claims that the defendant made a promise and didn't keep it, and the plaintiff asks the court to enforce the contract. For example, in Mills v. Wyman, Mills alleged that Wyman had promised to pay Mills for taking care of his son, and he didn't do it. Similarly, in Feinberg v. Pfeiffer, Feinberg alleged that the Pfeiffer company had promised to pay her a pension, and that it didn't do it. In both cases, the plaintiff asked the courts to enforce the promise. Secondly, we saw that a court will not enforce the defendant's promise unless the plaintiff can show a basis for enforcement. What are bases for enforcement? Well, the 3 modern bases for enforcement are consideration, reliance, and moral obligation. In seeking to prevent enforcement, the defendant may argue that the plaintiff cannot show any one of these 3 bases for enforcement. Let's start by talking about consideration. Consideration for the defendant's promise may be either a promise or a performance that is bargained in exchange for the defendant's promise. Now, what's the defendant going to argue? Well, the defendant will argue that the plaintiff can't show these 2 elements. We saw 2 arguments for why the first element might not be shown. First, the promise given in exchange is a promise to settle an invalid claim, and the plaintiff did not have a good faith and reasonable belief in the possible validity of the claim. That's the argument that Louis Figa tried to make in Figa v. Bohm. The alleged consideration was Hilda Bohm's promise to settle her bastardy claim. That claim turned out to be invalid, but the court held that she did have a reasonable and good faith belief in its possible validity. The second argument is that the promise given in exchange is illusory because it doesn't impose any express or implied commitment. That argument worked in Strong v. Sheffield. Strong had promised not to collect the money until he wanted it, but the court said that could be any time, so Strong wasn't really making a promise. However, as we saw in Matty v. Hopper and Wood v. Lucy Lady Duff Gordon, sometimes the court will find implied promises, like a promise to exercise reasonable efforts or a promise to act in good faith, which do impose a commitment. Now, we also saw 4 arguments for why the second element of consideration might not be shown. The first of these 4 arguments is that the promise or performance given by the plaintiff had already been received by the defendant and thus was not given in exchange for the defendant's promise. For example, in Feinberg v. Pfeiffer, Mrs. Feinberg had already worked 35 years before they promised her the pension. Therefore, the 35 would not be consideration for the promise. The second of these arguments is related. The second argument is that the promise or performance given by the plaintiff was not given until after the defendant's promise, and thus was not given in exchange for the defendant's promise. We saw that argument in Feinberg v. Pfeiffer also. Mrs. Feinberg did work 18 months after they promised her a pension, but the pension had already been promised before she undertook to work that time. Similarly, in Strong v. Sheffield, Strong actually did forbear for 2 years after Sheffield promised to guarantee his debt, but he didn't have to do that. He only had to wait until he wanted the money. We saw one contrary example, and that was Central Adjustment v. Ingram. In that case, the court held that the actual employment for 2 years of 3 employees was consideration for the employee's promise not to compete, even though that actual employment did not occur until after they had made the promise and wasn't bargained for. That case simply does not square with the bargain theory of consideration. It's just a different view about what consideration requires. The third of these arguments is that the defendant's promise was a conditional promise to make a gift. And although the plaintiff may have taken certain steps to satisfy the condition, the defendant did not seek these actions in exchange for the defendant's promise. We saw that in an example of Kirksey v. Kirksey. In that case, Kirksey promised his sister-in-law in Tellico that he'd give her a place to stay if she came down to see him. But coming down to see him wasn't something that was bargained for in exchange, it was merely a condition. He couldn't give her a place to stay while she was away. Finally, the purported bargain for exchange was just a sham and not really an actual bargain. Now, in addition to these arguments, we also consider two invalid arguments, two arguments that won't work for why there's no consideration. The first of these arguments is that the promise or performance given by the plaintiff cannot be consideration, even though it was bargained for, because it didn't benefit the defendant or impose a detriment on the plaintiff. That was the argument that was tried in Hamer v. Sidway, but it didn't work. In addition, another invalid argument is that the promise or performance given by the plaintiff cannot be consideration because it was less valuable than the defendant's promise. So, for example, in Figa v. Bohm, Hilda Bohm's promise to give up an invalid claim was a lot less valuable in the end than Figa's promise to pay support, but it turned out that didn't matter. The promise was still enforceable. Now, what about reliance as a basis for enforcement? Well, let's start out with just a definition. When a court enforces a promise on the basis of reliance, the court is said to be enforcing the promise by means of promissory estoppel. The two terms are synonymous. If you enforce a promise on the basis of promissory estoppel or on the basis of reliance, you're talking about the same thing. Now, one thing that's confusing is that to enforce a promise based on reliance, the plaintiff must show not only reliance, but 4 additional elements. In particular, the plaintiff must show that the defendant made a promise, that the defendant could reasonably expect the plaintiff to take an action, that the plaintiff took an action, that the action was induced, in other words, taken in reliance on the promise, and that enforcement of the promise is necessary to prevent injustice. All of these elements are found in the Restatement Second of Contracts, Section 90. Now, what will the defendant argue? Well, the defendant will simply argue that the plaintiff can't show all of these 5 elements. For example, the defendant might argue that the promise did not induce the plaintiff to take any action that the plaintiff would not have taken anyway. The Pfeiffer Company tried that argument in the Feinberg v. Pfeiffer case. It argued that Mrs. Feinberg would have retired anyway. The court didn't accept that, however. In addition, we saw that another possible argument is that enforcement of the promise is not necessary to prevent injustice. Again, in Feinberg v. Pfeiffer, the Pfeiffer Company argued that the promise didn't need to be enforced because Mrs. Feinberg could simply get another job. The court, however, also rejected that argument. We saw a similar argument in the Cohen v. Cowles Media case. Now, what about moral obligation as a basis for enforcement? Well, here, the general rule is that a court will not enforce the defendant's promise merely because some people might think that the defendant acted immorally. We saw that in Mills v. Wyman. The court made quite clear that it thought that Wyman was acting immorally, but it saw no basis for contract. Immorality is not a basis for enforcement. But there are some recognized special cases. Even if the plaintiff cannot show consideration or reliance, 3 types of promises are said to be enforceable on the basis of moral obligation. In particular, a court will enforce a new promise by the defendant to reaffirm an old obligation that was discharged by the statute of limitations, that was discharged by bankruptcy proceedings, or that was voidable because of infancy. In addition, some courts also will enforce the defendant's promise to pay the plaintiff money in recognition of a material benefit that the plaintiff conferred on the defendant. That's what happened in Webb v. McGowan. But not all courts accept this view, as we saw in Dementis v. Estate of Tallis. Now, the defendant's argument is simply going to be that the promise that the plaintiff is seeking to enforce is not one of the special kinds of promises that courts will enforce on the basis of moral obligation. Now let's talk about restitution. When the plaintiff cannot prove that the defendant made an enforceable promise, the plaintiff still may seek restitution from the defendant if the defendant has been unjustly enriched at the plaintiff's expense. The defendant must pay the reasonable value of any benefit received from the plaintiff. We saw an example of that in Cottenham v. Wisdom. Dr. Wisdom took care of a man who had fallen from a streetcar. Even though the man was unconscious and couldn't possibly have entered into a contract, Dr. Wisdom had conferred a benefit on the man, and it would be unjust for him or for his estate not to make restitution to Dr. Wisdom. Now, what can the defendant argue here? Well, the defendant will simply argue that there has been no unjust enrichment at the plaintiff's expense. And we saw 3 possible arguments that the defendant might make. First, there's been no unjust enrichment because the plaintiff conferred the benefit as a volunteer, manifesting no expectation of compensation. Secondly, there's been no unjust enrichment because the plaintiff conferred the benefit as an officious intermeddler. And third, there's been no unjust enrichment at the plaintiff's expense because the plaintiff has other remedies. We saw that in the Colano v. Oakwood Park Homes case. Colano didn't have to recover from Oakwood Park Homes because it could recover from the Pendergast estate based on the Pendergast promise to pay for the shrubbery. Those are some of the rules that we've learned concerning basis for enforcing contracts. Thank you very much for listening.